Of jury selection in the trial of the three men accused of confronting and shooting to death 25-year-old Ahmaud Arbery in February of 2020. Before I get into the details of the case, let me just say it is troubling to me that attorneys are out there at the courthouse already calling for a particular verdict before the trial even begins. I think it's bad for the justice system. It's bad for our faith in the verdict, whatever it may be. Now, this video is hard to watch. You see Travis McMichael and his father, Gregory McMichael, trying to stop and then eventually killing Ahmaud Arbery while he's jogging. Family friend William Bryan is behind filming it all. Bryan and the McMichaels reached charged with 9 counts, including felony murder. 3 men also face federal hate crimes in a separate trial expected to begin in February. To make matters worse, the prosecutor at the time seems to have tried to protect the men and has now been indicted for it. This is not an easy defense. It rests on a two-pronged approach, it seems, a reliance on Georgia's since amended citizens arrest law and arguing that they were acting in self-defense. The 1863 citizens arrest law was a real law that was on the books and was incredibly broad. It allowed any Georgia citizen to, quote, arrest another if a crime was committed in their presence or within their, quote, immediate knowledge. The McMichaels have said they thought Arbery matched the description of a man responsible for a series of burglaries in the neighborhood, and they were trying to detain him. Also seems Ahmaud had walked onto a home construction site a little before the time it happened, but taken nothing. The defense will also likely argue that Ahmaud was the aggressor. And it's hard to believe, but the reason the tape was released is that a lawyer for one of the defendants actually thought it would help them. So the video will make this a tough case for the defense. But the jury should evaluate the case without outside pressure from groups demanding a conviction before the trial is even underway.
This is not the Arbery family fight. This is not the Brunswick community fight. This is not the state of Georgia fight. This is the fight of the United States of America for the people. I'm certain that justice is served in the person and the death and the killing of Ahmaud Arbery.
Say his name. Ahmaud Arbery. Say his name. Say his name. Justice has to be achieved for Ahmaud Arbery.
We expect full justice for Ahmaud Arbery.
Let's be clear. Justice here means one thing, a conviction. I'm not just talking about people expressing their opinions. I'm really talking more about the lawyers who should have a higher standard to let the case play out and let the jury make up their own minds. I believe this pressure detracts from the sense of a fair trial and could make many question whether justice was really served here. If the jury does convict, we should all want them to do it based on the evidence. That's why there's such a painstaking jury selection process in place. Joining us now to discuss is Gerald A. Griggs, an Atlanta area attorney and vice president of the NAACP Atlanta chapter, who attended a rally yesterday in front of the Glynn County Courthouse, where he told the crowd, quote, "We no longer intend to beg for justice. We demand it. We expect it." Sir, thank you for coming on the program. Appreciate it. So do you think that I am being unfair here in asking that attorneys not prejudge the case and simply allow the jury to decide based on the evidence?
I think you're being a little bit unfair. Attorneys have a First Amendment right just like anyone else, and many of the attorneys that you just cited are advocates for their clients, so they have to be zealous advocates within the bounds of the law. The bounds of the law does not constrain them from being able to voice their opinion or the opinion of their clients.
Well, I'm not suggesting it's against the law. I'm just suggesting that it's bad form, bad practice, that I would think, and also bad for the legal system, when lawyers are out there, and I mean this about any case, by the way, but because this is a very high-profile case that we'll be covering, I'm focused on this one right now, it seems to me it is bad for the legal system when prominent attorneys like yourself and like others are out there calling for a particular verdict. I mean, it feels like what you're saying is if the jury doesn't get this verdict, then they've gotten it wrong. And it just seems to me that's pressure we don't need on jurors in a case where it's already going to be really hard to find a jury.
Well, I think that it's the incumbent upon the lawyers that are actually in that particular litigation to ensure that the rights of their clients are protected, just like we're protecting the rights of our clients. This is a very high-profile, highly polarized trial. It's also caught on video. So many people have decided the case. Now it's up to the judge and the litigants in the case to make sure they pick a impartial jury that's honestly seeking the truth. But as far as the lawyers who are not participants, who are not under any gag order, they can express the opinion that they have formed for their clients, or they may have formed independently. This is America, it's United States of America. Everyone has a First Amendment right. Just because you're an attorney does not mean that you shed those constitutional rights at the courthouse door. Many of those attorneys have not walked into the courthouse door on this particular trial.
Well, but it does very often, being an attorney, does restrict your First Amendment rights in a lot of different ways. Attorneys are held to a higher standard by the bar associations, et cetera, and they're talked to, for example, in ethical issues. They're not allowed to say certain things other people might be able to say. So let me ask you, rather than sort of talk about it theoretically, just ask about yourself. I mean, you are clearly demanding a conviction. Is that fair to say?
I am clearly demanding justice, and they follow the law, the evidence. Simply going by the Georgia bar rules of professional conduct, I have not said anything that's untrue, nor have I tried to bias any litigant in the case. I am merely expressing my opinion and the opinion of my client, the NAACP.
Right, and that position is that there ought to be a conviction, correct?
That position is the video is clear, the motives of the individuals involved are clear on the body cam footage. The witnesses that we have previously interviewed are quite clear. This case is a horrific hunting of a man, and someone should be punished for that criminal activity. Now, if the jury finds differently, we will respectfully disagree with the verdict of the jury, but we are entitled to our opinion and our view of the facts and the evidence in this case.
But I guess my only point is, and I'll give you the final word on this, my only point is that I wish that that opinion of the evidence would come after the evidence is in, rather than before. Your final word.
Well, here's the problem. Here's the problem. There were 3 district attorneys who spoke and prejudged this particular case. So it took the NAACP, it took the family of Ahmaud Arbery, it took the citizens of Glenn County to even get us to this point. So to merely say that you would hold accountable attorneys who are advocates for their clients to a higher standard than the sitting district attorney who's now been indicted, that's an indictment on more of the system.
No, I'm not saying a higher standard. No, I'm not saying a higher standard. That district attorney has been held accountable. She's now facing criminal charges for what she did. I'm not suggesting anyone on your side should be facing criminal charges. I'm just talking about the ethics of lawyers and simply waiting for the evidence to come in a case like this, because I think that this is, as I said many times, this is a tough defense. You look at that video, and this is a tough defense. I'm not saying anything otherwise. I'm simply asking you, as an attorney, whether wouldn't it be better if, rather than protesting outside, demanding a conviction, you simply demanded a fair trial, and that's it, and simply said, we want a fair jury? Because I would think if everything you're saying is true, if you find a fair jury, that you will probably end up being satisfied with the verdict rather than prejudging. Anyway, I said final word. I'm going to give you one more final word because I just took it from you.
I appreciate that, Dan. And understanding who my client is and the situation that faces us in Glenn County, I believe that everything will be done appropriately. I'm a zealous advocate for my client, as other lawyers will be for theirs. We have merely voiced our opinion, which we're entitled to do under both the bar rules as well as the Constitution. Hopefully, they can pick a fair, impartial jury, and as soon as the evidence comes in, they will come to the same conclusion that many people in Glenn County, including the Glenn County NAACP and the state conference of the NAACP, have come to. And that's people need to be held accountable for hunting an African-American man who was unarmed and merely jogging through a neighborhood.
Gerald Griggs, thank you very much for taking the time to come on the show. Really appreciate it. And I did give you the final word.
Thank you. Thank you.
Coming up.